And we are recording again.
Thank you. Good morning, everyone. I will call the meeting of the Regulation and Discipline Committee of the State Bar Board to order. Welcome to the meeting. As a reminder, this meeting is being recorded. Justin, could you please take the roll?
Broughton.
Here.
Chen.
Here.
Cisneros.
Here.
De La Cruz.
Here.
Duran.
Here.
Ganong. Saleg. Shelby.
Present.
O.
Present.
Stallings.
Here.
We have a quorum.
Thank you. Next on the agenda is a call for public comment. For those of you on Zoom video, you can raise your hand. For those on the phone, you can virtually raise your hand by pressing *9. That's the star key, then number 9. Not seeing any hands, but let me wait for a second in case folks are trying to find the raise hand function. Okay, looks like there is no public comment. I will move to the chair's report, which is very brief. First of all, Happy New Year, everyone, and I'm very excited for our board strategic planning session today. Just wanted to give folks an update that the State Bar staff and OCTC and other departments have been hard at work working on a proposed set of case processing standards and staffing requirements to meet those proposed standards. That includes defining what complex cases are. It will include surveying the public. The final proposal is going to come to the board, we anticipate, in March. And so keep an eye out for that. We'll have a bigger update then. Our quarterly meetings between members of the Board of Trustees and the State Bar Court judges and the State Bar Court clerk of the court happens quarterly, and the next meeting is going to take place next week. So that's it. That's my report. Oh, it looks like, and Christine has joined. Hey, Christine.
Hello, everyone. Good morning.
Good morning. Okay, hang on one second. I'm having a issue with my screen. Okay, next on the consent agenda are the open session minutes from our last meeting on November 18th. Does anyone want to pull this item off of consent? Okay, are there any corrections or modifications to these open session minutes?
It's Jose. I'll move adoption.
Second.
Thanks. So motion by Cisneros, second by Duran. Justin, could you please call the roll?
Broughton.
Yes.
Cisneros.
Aye.
De La Cruz.
Yes.
Duran.
Yes.
Ganong.
Yes.
Saleg. Shelby.
Yes.
Soul.
Yes.
Stallings.
Yes.
It passes.
Thank you. Next item on our agenda, on our regular agenda, is a proposed amendment to the Client Security Fund rules regarding electronic service. This is a return from public comment and a request for approval. We will hear a presentation from Lori Malak, Program Director, and Matt Zaywald, Supervising Attorney from the Office of Professional Support and Client Protection. And I see they have both joined us. Welcome.
Good morning.
Good morning. My name is Lori Mellock. I'm the Program Director of the Office of Professional Support and Client Protection. I'm here with Matthew Zaywal, who is the Supervising Counsel for the Client Security Fund. And we are bringing before you an item that it was brought to the November meeting where it was approved to go out for a 30-day public comment period. These are proposed amendments to the Client Security Fund rules to permit the electronic service of CSF decisions, and to permit the use of electronic signatures. No public comments were received during the 30-day period, and as such, we recommend the approval of the proposed amendments in the form approved for RAD by circulation for public comment. Are there any questions? Thank you.
All right, thank you, Lori. Any discussion by the committee? If not, may I have a motion?
So Zay, I'll make the motion.
This is Brandon. I'll second.
Great, motion by Cisneros, second by Stallings. Justin, could you call the vote, please?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Yes.
Ganong,
Yes.
Saleg, Shelby,
Aye.
Sol,
Aye.
Stallings.
Yes.
The motion passes.
Thank you.
Thank you.
Thank you. Next item on the agenda is amendments to rules 5.65, 5.337, and 5.345 of the rules of procedure. This involves discovery. This is a return from public comment and a request for approval, and Chief Trial Counsel George Cardona will be presenting. Good morning, George.
Good morning. So this is a return from public comment on proposed amendments to 3 rules. They went out for a 45-day public comment period. We received 3 public comments, and we also received an informal inquiry to OCTC from the State Bar Court. So with respect to the amendments, with respect to the proposed amendments to Rule 5.65, there was no disagreement with those amendments, and so we're not recommending any change to those. With respect to the amendments to Rule 5.337, 1 public comment objected to the addition of the word co-counsel in certain portions of the rule, but as we've explained, co-counsel is already included in the notices that are required to be provided under Rule 9.20, and so its addition to this rule is part of the effort to align the discovery rule with the notice rule so that we can get the information necessary to see if there has been compliance with the notice requirements of Rule 9.20. So we're not recommending any change to the amendments that were previously proposed to Rule 5.337 either. With respect to Rule 5.345, this was the amendment proposing the addition of a provision that would allow OCTC in criminal conviction referral cases to take the deposition of the respondent for purposes of ascertaining whether there are facts that support moving forward with discipline in the event that it is not a per se conviction that demonstrates moral turpitude per se, in which circumstances we have to demonstrate that there are facts either rendering it moral turpitude or rendering it other conduct that would justify discipline. To remind everybody, this is a unique situation in which OCTC, once it receives the final conviction, is required by statute to refer it to the review department for the initiation of disciplinary proceedings within 30 days. And so we do not have a time period in which we can conduct an investigation. In ordinary cases where we have more time, pre-initiation, our rules and the State Bar Court rules allow us to conduct depositions. So in effect, this amendment is simply to give us the ability in these unique criminal conviction referral cases post-initiation to conduct the type of investigation or a portion of the type of investigation that we would be able to do pre-initiation in most other cases because of the difference in the time periods. The objections, we received two public comments that objected, one from an individual and one from the California Association of Black Lawyers. We've addressed those at some length in the written materials that were provided, but there are 2 points I want to make. First, in terms of Fifth Amendment rights, which was raised, nothing in this alters the ability of anyone to assert Fifth Amendment rights in response to the request for a deposition. And importantly, that deposition would only be conducted because of the nature of criminal conviction referrals after the appeal of the criminal conviction is final. So they would have already had their appellate rights before it comes to us. And under statute, they can exercise their Fifth Amendment rights, and there is no penalty for that assertion. In other words, no negative inference can be drawn. Second, in response to primarily the comment from the California Association of Black Lawyers, which noted in particular the potential burdens of a deposition on the respondent and the concern that that might result in disparate impact, they suggested an alternative to depositions in the form of written discovery, but for reasons we've discussed in the written proceedings, we don't believe those alternatives would provide the same mechanism. In other words, a deposition provides the ability to do things that you simply can't do in written discovery. Confront a witness with documents, ask follow-up questions, clarify answers on the spot with them present to address that. We understand the concerns about the burden, and in response to that, we've added a clarifying sentence or proposed a clarifying sentence to the amendment to make clear that the depositions can be conducted remotely, which would effectively remove the burden of personal appearance and decrease the cost of that. It was never our intent by the language in the amendment to preclude remote depositions to the extent those could be conducted in accordance with state law. And so we've added a proposed sentence to clarify that in fact they can be conducted remotely, which we believe addresses the burden issues that have been raised. That's also consistent with the inquiry we received from the State Bar Court, which inquired whether we intended to allow remote depositions in accordance with state law, and that was our intent to the extent they are permissible. Indeed, we expect to come back to the board at a later time with a more general amendment to allow all of the depositions that we're allowed to be conducted remotely in accordance with state law, again, for the same reason. So with this modification and with our commitment to monitor as we go forward to see if in fact there are any racial disparities that arise from this rule, if we are using it improperly to conduct depositions more of one particular class of individuals than others, which we will continue to do, we recommend adoption of the amendments with this additional clarifying sentence to make clear that it was never the intent to preclude and that indeed the intent is to allow remote depositions. So with that one modification, we recommend adoption of the rules, the amendments as previously proposed and circulated for public comment with that one clarifying amendment. Shall I take questions? I see that Ms.
Yes,
Shelby has her hand
certainly,
up.
Melanie, go ahead.
Yes, thank you for that. My question, I'm sorry, I've been having coughing fits all day. My question was, has there been any follow-up with cable? When I saw that a letter came from an organization representing such a broad constituency, I was wondering if there had been any outreach in terms of what the clarifying statement would be. And then the other piece was, I know that there were two things that they identified, notice and representation, and then what was the conclusion on the second piece?
I'm not sure, notice and representation.
I was referencing the letter that they sent. So in their letter, and forgive me because I'm not a lawyer, I understand that you all are providing clarifying language as it relates to depositions and the fact that depositions can be done remotely.
Correct.
And then also in their letter, they raised a concern around, let me look at this letter.
I see where you're
So
saying,
the
Melanie.
concern about
Yes.
notice to be provided to attorneys.
In
that
terms of,
provide
yes, if you look at the second page, in terms of the fourth or fifth paragraph, they were raising that in relation to representation during a deposition.
So that would be the normal notice that we give in any deposition. In other words, we provide notice to people in California in accordance with our normal rules.
Sure.
The provision in the rule is specific just to make sure that we have the ability to do that for people who are outside California. Within California, we would provide notice in accordance with our ordinary standards that we apply in all of the other instances where we have to give notice.
Okay. And then my follow-up was there any outreach to the cable organization? I know that we have our vice chair of COAF is in leadership at cable, and I didn't know if there had just been any outreach to say, hey, we heard you and we're going to resolve this piece of your issue.
So can I turn to Leah because I believe she had some communications with cable.
Sure, I did reach out to the author of the letter, and the cable leadership, including the vice chair of COAF and Ms. Sinead Buffington, who has been a really valuable member of several state bar committees at currently the Ad Hoc Commission on the Discipline System. So I did reach out and share my interest in connecting with them and connecting them with George specifically. And they have indicated that they will be getting back to me shortly.
Okay, but in relation to the issues that they outlined in the letter, did they not respond or?
I sent an email that they did respond to. We did not have a substantive conversation yet, which is what I was asking to schedule.
Okay. And I just raised that, and I think it's great that you all reached out, but I just wanted to raise that particularly because I know I tend to talk about optics, relationships, and narrative. And I thought this was a great opportunity because we had received this letter from this organization to reach out and say, we heard you, we understand the issues that are of importance to you. And so let's have a conversation in advance of us moving forward with a change to the proposed rules so we understand the vantage point in which you stand as you represent 6,000 African-American attorneys, and we understand the disproportionate discipline of African-American male attorneys in the state of California. So I feel it was resolved, but I feel like I don't want to be a broken record, but I just wanted to make sure that I raised that because I felt like that was very important, particularly considering the work that this committee has in front of it.
Are there other questions?
Yes.
Ruben and then
Madam-
Brandon.
Thanks, Madam Chair. Mr. Cardone, you mentioned sort of monitoring to double check or make sure that there's not a disparate impact in the implementation of one of the last things you talked about. What is that process? Is that someone designated in your office to check on that issue, check on those statistics, for lack of a better word, or is there something else?
So it would essentially be someone in my office will simply keep track of what depositions we do and see that we do them. I don't expect that there will be that many. So I don't think it'll be that hard to monitor the depositions that do occur and see if we see any patterns in when and how those are conducted that would cause concern.
And is it your intention, or is it possible to update RAD periodically with sort of where we stand on those issues?
Yes, we can certainly come back and give you a report on what our monitoring shows and when we have conducted depositions and what those cases are.
Thank you.
Thank you, Ruben. Brandon?
Right, I just wanted to thank all the public commenters who took time to address this issue, especially cable, and also wanted to thank staff for what I see as a very thoughtful and well-written response, especially when it's pointed out that this rule doesn't change the statutes that really undergird this aspect of our prosecution, particularly business and professions codes, sections 6101 and 6102, but that it changes that discovery mechanism. And so after reviewing this agenda item, think, it seems like the issues raised are addressed in my mind. And on that, I'm happy to move this item.
Thank you, Brandon. Do we have a second?
A second, Duran.
The motion from Stelling, second from Duran. Any further discussion? No, George, am I correct that this is this deposition is just extending a process that already exists for pre-initiation to?
Yeah, so normally in, for example, our non-criminal conviction cases, in the course of our investigations, we have the ability to compel witnesses to come in and attend and provide testimony in the form of a deposition. That would be done in the pre-initiation stage because there isn't the equivalent, tight 30-day time frame that we have from the date we get the criminal conviction to when we have to refer it.
Got it. Okay. Any further discussion? You can't. Did the amendment, the change that you discussed, George, with about remote depositions make it into the language, or no? We're satisfied there's nothing that prevents remote depots from occurring.
No, we added a sentence. So we added to a clarifying sentence that reads, the deposition may, however, be conducted remotely in accordance with Code of Civil Procedure, section 2025.310. That Code of Civil Procedure was added to effectively carry forward Emergency Rule 11, which allowed remote depositions during the pandemic. And so it now has provisions under which depositions can be conducted remotely.
I see. Okay.
That was
so
the
you're
inquiry. That was the inquiry we received from the State Bar Court, referencing that Code of Civil Procedure provision and asking if it was our intent to allow them to proceed remotely in that way, which it is.
Got it. Okay, so that's at the bottom of page 17.
Yes, and in red line on page 18.
I see. Okay. Thanks for bearing with me. Any other discussion? Justin, could you call the vote, please?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Yes.
Ganong,
Yes.
Selig, Shelby,
Aye.
Sol,
Yes.
Stallings.
Yes.
The motion passes.
Thank you. The last item on our open session agenda is a proposed amendment to Rule 5.21 of the Rules of Procedure. This concerns the limitations period. This is a request to circulate for public comment, and George will be presenting on this as well.
Thank you. So Rule 5.21 of the Rules of Procedure is the rule that sets out the limitations period within which disciplinary proceedings have to be initiated. As it currently stands, it implements, in essence, a general 5-year limitation for disciplinary proceedings that arise from a complaint filed by a complainant. It provides for a number of tolling provisions, and it exempts from that 5-year limit investigations and disciplinary proceedings that are based on an independent source. We're proposing amendments to address a couple of issues that have come up over time in terms of this. So first, the 5-year time limit, the general 5-year time limit is tied to the end of the violation. As you know, most of our complainants are not lawyers, and so there are occasions where we get complaints filed by complainants very close to the end of the 5-year period. But because our time isn't tied to the complaint, but rather to the time of the violation, that could put OCTC in the period of having an extraordinarily short time period to conduct investigation and determine whether to proceed, even though it's received a complaint. So what we're proposing is that the general time period be modified to be an alternative, the later of either 5 years, or if a complaint is filed within 5 years, 2 years from the complaint. So for example, if a complainant filed a complaint at the 4-year mark, we would have 2 years from then to initiate the disciplinary proceedings. And this is intended to address the concern we have that complainants who are not lawyers, who don't understand that 5-year limit, will not understand that they should have filed sooner and will in fact file late. And so it'll give us time to investigate and proceed. Second, with respect to some of the tolling proceedings, we're proposing some clarifications. First, to make clear that the tolling that currently applies to representation extends to situations where the attorney not only represents in an attorney-client representation, but also where that's a fiduciary duty. And that's consistent with a review department decision that held that, and this will make that explicit in the rule. Second, to provide that the tolling for related civil, criminal, or administrative actions extends to actions taken to remediate the violation, including efforts to collect funds. This is because in our experience, those efforts to collect funds or similar types of actions, in fact, often involve determinations of the nature and scope of the conduct, the harm resulting from the conduct that can be very relevant to decisions as to whether to initiate discipline and what level of discipline to seek. And so we're proposing that that be added to the tolling proceeding. In addition, the tolling currently applies and allows us 2 years after review of our decision to close a complaint by the Office of General Counsel's Complaint Review Unit. There is no mention in the rule of the potential review by the California Supreme Court and an order by the California Supreme Court after a Walker petition to basically send it back and tell us to reopen. And so we propose amending the tolling provision to explicitly reference that review process as well, and give us 2 years after that review process is complete to initiate discipline if the California Supreme Court has sent it back to us after review. Similarly, we're suggesting a modification if a complainant dies within the time period in which they could have filed a complaint. We're proposing that we have 2 years from the death to, so it provides that a family member or the estate has 2 years from that event to file a complaint. And we are proposing that we make explicit that we have 2 years from the date of that filing to initiate disciplinary proceedings, again, to give us time to investigate after that is filed. Finally, we're proposing some clarifications of the independent source exception. This has arisen, we're proposing this because of situations along the lines of the following. The rule right now doesn't define what an independent source is, and issues have arisen in situations such as this. For example, we have received complaints from academics where academics have basically, as a result of research in media reports or in court dockets, have identified situations where the particular example is where they believe there's been prosecutorial misconduct, and they have referred it to us on the basis of their independent research into media reports and or court dockets. But that comes in as a complaint from the academic. The rule is unclear as to whether that is a complaint from a complainant and hence subject to the 5-year rule, or whether this is simply a referral of independent source material that would exempt it from the 5-year rule. We're proposing a clarification to make clear that those types of documents, media reports, court dockets, court documents, are independent source, and that it's treated as an independent source, even if the independent source information is brought to OCTC's attention by a complainant, such as an academic, to enable us to conduct investigation and proceed with the disciplinary proceedings. In addition to those kind of major substantive modifications, there are a number of other minor modifications for clarity and consistency to clean up the language and make sure that it all holds together. So those are our proposed amendments, and we're requesting that they be sent out for a 45-day public comment period.
Thank you. Any questions? Brandon?
I had a couple of questions. So the first is, are complainants notified of the current statute of limitations, or I guess that whole timeline right now? And if not, is there a thought about how best to convey, what, if any, statute of limitations the board adopts?
Yeah, so I mean, this is the fundamental problem, which is that because so many of our complainants are, they're not lawyers, they're not educated in the law, they are, for example, clients. They may not even look at something to see whether there's a statute of limitations until we're already deep into that statute of limitations. I agree with you. I think we need to do more to kind of get out there that, look, these are the time limits, and we do have those announcements out. But the problem is that sometimes people who want to file a complaint don't think about doing that until some time period significantly after the event. So it's not clear that even our outreach and educational efforts would necessarily reach people and let them know, unless they actually are thinking about, until they actually start thinking about doing a complaint.
And my second comment just relates to the body of case law relating to the criminal statutes regarding statute of limitations and this idea that the fresher the complaint, the more due process that's provided to both the victim as well as the individual being accused. And so, I really do support a rule that has exceptions to it, recognizing that sometimes misconduct is covered by sophisticated bad actors, but also a rule that balances that with fresh complaints, keeping in mind that witnesses' memories fade, documents may become lost. So I really do support this idea of a statute of limitations. I do recognize that it seems like it's in that it doesn't align with the ABA statements made about this topic, but I think for due process as a whole, this is a good idea.
Yeah, and we haven't proposed that we move away from any statute of limitations whatsoever. We view these as kind of tweaks to kind of balance your concerns with the desire to allow complainants to the extent possible to get their complaints in and us to have some time to investigate them, so they don't disappear simply because there's not time to investigate.
Other questions, discussion?
Madam Chair, I'm happy to move this item.
Okay, thank you. Motion by Stallings. Do we have a second?
So Zay, I'll second.
Second by Cisneros. Justin, could you please call the vote?
Cotton,
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Duran,
Yes.
Ganong,
Yes.
Saleg, Shelby,
Aye.
Soul,
Aye.
Stallings.
Yes.
Motion passes.
Great, thank you. So that brings us to the end of our open session items. We will now move into closed session pursuant to Government Code Section 1126A and 11126A and Government Code Section 11126A1. The committee will move to closed session to discuss Rule of Procedure 2201, case status update and evaluation of Chief Trial Counsel. The open session meeting is now adjourned.
And members, you will have received a link from me just now to join the closed session.
Okay, we will see you all in closed session.
George, I had assumed you were part of closed session.
I am waiting for the link. I have not gotten it yet. I just sent Justin an email.
I forwarded you mine. I received a link. Maybe, maybe he thought I was going to have my performance evaluation done.
Doug, I have a quick question. Are you seeing the slide? On my end, it's just black.
I did see it briefly. Let me forward this to George real quickly.
Okay.
No, I just got it.
Okay.
Just got it from Justin.
All right.
Thanks.
Of course. I saw it briefly, and now let me go back into Zoom, and I'm not seeing anything right now.
Okay, that's really strange.
you want to share with me or send me the file and I can post it?
Okay.
We appear to be recording still. I'm going to stop that,
Oh, thank you.
of course. I'm going to pause it, right? Not stop it.
Pause.
Let me cancel that. Pause.
All right, we are recording again.
Okay, we are back in open session of the Regulation and Discipline Committee. We have just returned from closed session and there was no reportable action. And with that, we can adjourn the meeting of RAD. All right, thank you, everyone. Ruben, do you want to set a time for when we'll pick up the next?
Yeah, thank you, Madam Chair. I was just going to suggest that we take a quick break, give folks a chance to refresh themselves. Thank you to everybody who's been on the line waiting for us to convene the Board of Trustees meeting. We've been going since 8:30 or since 9 o'clock this morning. So let's take a 12-minute break and reconvene sharply at 11:15. We'll see you here then. Thank you.